Grenfell. Katrina Grenfell is a barrister at Murray Chambers, Adelaide. Before returning to Adelaide in 2018, she worked for over 17 years as a lawyer in the United Nations office as a legal counsel at its headquarters in New York, where she advised on UN peacekeeping operations worldwide and issues of international humanitarian and human rights law. Her assignments included working in the Timor-Leste in 2009 and as a senior legal officer in UN OPCW Joint Investigative Mechanisms investigation into the use of chemical weapons in Syria in 2017. She now enjoys a varied practice at the South Australian Bar, ranging from administrative law, criminal law, estate law, equity and environment and planning law. I now request Swati ma'am to felicitate and present a token of appreciation to Ms. Katrina. Thank you, ma'am. Our second speaker for this technical session is Advocate Rajendra Barot. Sir is a senior partner at one of the most reputed firms, AZPN Partners. With an experience of more than 24 years, Sir heads the dispute resolution practice. Sir has advised and appeared in various fora on matters relating to maritime law, IPR, regulatory and securities law, monetary suits, etc. Sir was ranked Band 1 for arbitration and ran for dispute resolution by Chambers Global. He was recognized as Litigation Star of the Year by Benchmark Litigation Asia Pacific. He was also recognized as a leading lawyer for dispute resolution in the year 2023. I would fall short of time by elaborating Sir's achievements to the gathering. Sir, we are extremely honored to have you on our panel today. I now request Mr. Sheetal Sethia to felicitate Sir and present a token of appreciation. Thank you, sir. With this, I now hand over the stage to Ms. Lauren Bravennick and request her to proceed with the session.
Thank you and good morning everyone. Without further ado, I'll introduce Katarina Grenfell. She is our first speaker. Her topic is on international law in domestic laws.
Thank you very much, Lauren, and thank you everyone for having me here. I have to say, it's a real pleasure to be here with you and to have this opportunity to engage with you in this comparative discussion of Australian and Indian law. So before I launch into my topic, I just wanted to tell you a little bit more about myself. So I came to the bar in Adelaide in 2018, and it was in rather unusual circumstances. As you've heard, I spent a long time at the UN in New York. In Australia, most barristers come to the bar after spending years of learning Australian law and court procedure, working in Australian law firms or in government practice. And as such, they come as really experts of the law to the bar before they launch into solo practice and become self-employed. But I did it after being overseas for 20 years. And while I'd been a prosecutor and a government lawyer for about 5 years before I joined the UN, when I came back, I knew hardly anything about the content of Australian law, let alone court procedure, and what I knew was very rusty. One thing that I did have was my robes from when I was a prosecutor still fit me, surprisingly, but that's about it, that's what I had. At the UN, I only advised on international law, and it was mainly UN law that applied in UN operations. And it would be very rare at the UN that we would have anything to do with national court proceedings. And if we did get involved in any case, it would only to be act as an amicus curiae, or as a friend of the court. And this is because the United Nations is immune from all forms of legal process. This is under the 1946 Convention on the Privileges and Immunities of the UN. And it means that all disputes involving the UN have to be resolved via arbitration or other means of agreement. But happily for me, there was an excellent bar readers course that I was able to undertake for 6 months before launching into solo practice. So that really helped me prepare for my new career as a barrister. And I was also very lucky that I happened to land in Murray Chambers, which has been a very supportive environment for me. And not only did members of my chambers send work my way, but they also showed me how to do it. So I feel very grateful for that. So today, I want to talk about international law in domestic courts. International law is a living and expanding body of law, and in my view, it's becoming increasingly important in a range of areas. And this is particularly the case in the field of human rights law and also in the field of environmental protection. I was also very recently involved in a case before the Federal Court of Australia, which was all about international law. And so I was working on that case when Brian came to me and said I had to come up with a topic for this conference. And that case made me think about how does international law apply in Australian courts? How is it used in Australian courts? I had no idea about that from my UN experience because it never came up. It also made me wonder about how Indian courts approach international law, particularly as India and Australia share some legal traditions. But before I get into the case that I was involved in, which I feel is very interesting, I just want to say a few fairly basic things about international law and how it applies in a domestic setting. And this is for the benefit of those who may not be very familiar with international law, including some of the members of my chambers. In Australia, it's possible to become a practicing lawyer and a judge without knowing anything at all about international law. And depending on your practice, it might not come up very often, and it might never come up. So some might ask whether international law is in fact law. And in my experience as a UN lawyer, this question would often come up at dinner parties in New York. This is because there's no international legislature, there are no courts of compulsory jurisdiction, and there are no centrally organised sanctions. But there is, of course, the General Assembly of the UN, but this doesn't legislate, so to speak. There is also the International Court of Justice, but states have to agree to exercising jurisdiction over specific disputes, and only then are its decisions binding. An answer that's been given to this quandary is that international law is law because states and non-state actors regard it as binding in their international legal relations. It's a different kind of system based on the sovereign equality of states, and it's based on rules that states themselves agree to. And it's where sanctions for breaches of the law can take various different forms. A major accomplishment of international law is its role in standard setting in the human rights field. And since the establishment of the UN in 1945, the international community has developed an impressive and comprehensive body of human rights law. And I've just set out there's the Universal Declaration of Human Rights and then 7 core human rights treaties which have had a significant influence on domestic legal systems around the world. So what are the sources of international law? I recently learnt that Australian courts have accepted that Article 38(1) of the Statute of the International Court of Justice sets out the sources of international law. And you can see them listed there. They comprise international conventions, international custom as evidence of a general practice accepted as law, the general principles of law recognised by civilised nations, and finally, judicial decisions and teachings of the most highly qualified publicists of the various nations as a subsidiary means for the determination of the rules of law. But when we talk about international law, we're mainly concerned with treaties and customary international law. And some examples of treaties are the human rights treaties that I referred to earlier. Norms in treaties are binding on states which are parties to the treaties, but they can also be binding on states which are not parties to the treaties, when the particular norms have the status of customary international law. And this is because treaties often codify customary international law, or certain provisions of treaties may attain the status of customary international law over time. So customary international law is law that's created by the general and consistent practice of states, and it has to be followed by them from a sense of legal obligation. Some norms are not contained in treaties, and in the case that I recently worked on, we argue that certain norms which are in the 2007 UN Declaration on the Rights of Indigenous Persons have the status of customary international law. And these are norms in relation to Indigenous peoples' land rights and their rights to cultural heritage and identity. It's not controversial that many norms of customary international law have the status of customary international law. Like there's slavery, there's the rule against piracy, the rule against torture. All of those, are widely understood as having the status of customary international law. But there are other norms which are considered more controversial, and this was the case concerning the rights of Indigenous peoples in my recent case. We'll just go back one. So, customary international law. So in order to prove that a norm has the status of customary international law, you need to prove two things. One, that there is wide and consistent state practice in relation to the norm. And secondly, something called opinio juris. And that is that states do the thing that is in the norm as they consider themselves legally bound to do so. So it's not enough that you have extensive state practice. You also have to prove that states do that, not just because they feel like it, but because they feel legally obliged to do it. We'll go to the next slide. And so a case that came up in Australia in 2016 related to an issue regarding a norm and whether it was part of customary international law. And this was the case of Eura against the Commonwealth. And I think that the facts in this case are quite interesting, because in this case, Mr. Eura claimed that he had a proprietary right over some islands up near Lord Howe Island on some reefs. And there wasn't much on these islands. They were barely islands, but they were associated with some very valuable hydrocarbon reserves, valued at over $1 trillion US. And he argued that no state had ever claimed to these islands, that they were not part of Australia or part of any other country, and that there was an old rule of international law that individuals can acquire proprietary rights over terra nullius, which rights are required to be recognised by nation states. And the issue before the court was whether there was a rule of customary international law that would give him proprietary rights over the islands. And so the court went into a whole process of setting out what is the test to establish something as customary international law. And it examined the evidence that Mr. Eura brought before the court. And I've set out there parts of there are some cases from the International Court of Justice which address the nature of the practice, and that has to be widespread and virtually uniform in terms of establishing a norm as customary international law. The court found that it wasn't satisfied that there was a rule giving him proprietary rights in that case. So there are two theories about the application of international law in domestic courts, and these are the theories of monism and dualism. So in a monist system, there's only one system of law, and international law, any treaties signed by that government are automatically part of the law of the land, just like the law of contract or employment law that is created by the common law in that country or under a code or in a statute. And in a monist system, any treaty signed by the executive of that country will be given effect and directly applied. And this is the system that applies in the Netherlands. In a dualist, apply upon ratification. And this is the system that applies in Australia and the United Kingdom, and I believe also India. And that action. There's international law, which is on one plane, and then domestic law on another. So, in respect of treaties, in a dualist system, they don't automatically apply. Instead, there has to be some act of transformation, as it is often referred to, and that is that the treaty obligations have to be given effect by Parliament to become part of the domestic law of the country. So, with respect to those 7 human rights treaties that I had up on the slide earlier, Australia has ratified all of those, but they don't create rights or impose obligations on Australians unless and until those rights and obligations are incorporated into the domestic law by legislation. Go to the next slide. And this was confirmed in a High Court case in Australia in 1995. This was a case of the Minister for Immigration against Teo. And in this case, the Minister for Immigration had decided to deport Mr. Teo from Australia. Mr. Teo was a Malaysian citizen. He'd been living in Australia. He had residency status, but he'd been found guilty of illegally importing heroin into Australia. And so the minister decided that he was not of good character and that he would be deported. But Mr. Teo had 7 children, and he argued when he took a challenge to the decision by the minister that the decision should be reversed, as the minister had failed to have regard to what impact this deportation decision would have on his children. And as Australia had ratified the Convention on the Rights of the Child, in which the principle is that the best interests of the child have to be taken into account, he argued that the minister had erred in deciding to deport him without taking into account the effect it would have on his children. So the Convention on the Rights of the Child had been ratified by Australia, but there wasn't any specific legislation implementing it in Australia. And in this case, the High Court held that it was well established that the provisions of an international treaty to which Australia is a party do not form part of Australian law unless these provisions have been validly incorporated into Australian law by statute. And they explained that the principle has its foundation in the proposition that in our constitutional system, the making and ratification of treaties fall within the province of the executive in the exercise of its powers, and that lawmaking falls within the province of Parliament and not the executive. And so they held that a treaty which has not been incorporated into Australian law cannot operate as a direct source of individual rights and obligations. I'll come back to that case a little bit later, but just for now, that's the statement in Australia, that a treaty which hasn't been transformed by domestic legislation in Australia doesn't create any legal rights. Coming to customary international law. So as I mentioned, customary international law is not necessarily law which is in a treaty. It's created by the general and consistent practice of states, which is followed by them from a sense of legal obligation. Customary international law is part of the common law in the United Kingdom. This has been the case ever since 1809, when Blackstone wrote that the law of nations, that is international law, is adopted in its full extent by the common law and is held to be part of the law of the land. This is subject to the qualification that it mustn't be inconsistent with statute or inconsistent with law pronounced by municipal tribunals. So that's the position in the United Kingdom. Customary international law is part of the common law. And it's also the position in Canada and New Zealand. It's not necessarily the case in Australia. And it's currently unclear whether or not Australian courts can apply customary international law directly as part of the common law, or whether some act of transformation into domestic law is required in the same way that treaties are transformed. But what is clear in Australia is that customary international law cannot create a direct cause of action in Australia. So this issue about the applicability of customary international law was addressed by the Federal Court of Australia in 1999 in two cases which were brought by the Arabunna Aboriginal people of South Australia. There was the case of Nuliarima against Thompson. And this concerned a request by Ms. Nuliarima to a court in Canberra to issue arrest warrants for the Australian Prime Minister, the Deputy Prime Minister and some members of Parliament for engaging in acts of genocide in relation to native title laws. There was also the case of Buzzacott and Hill, and Kevin Buzzacott was also a man who was a member of the Arabunna Aboriginal people, and he's quite famous in Australia because he actually set up a tent embassy outside of Parliament House in Canberra to raise awareness about issues facing Indigenous people. And he brought an action seeking an injunction from the Federal Court in respect of the Minister for the Environment and the Minister for Foreign Affairs for failing to enter the ancestral lands of the Arabunna people, which included Lake Eyre in South Australia, into the World Heritage List on grounds that not protecting these lands and allowing them to be mined by mining companies constituted acts of genocide, because those acts would end up destroying the Arabunna people. I have to say, both of these cases were heard together by the Federal Court, and I have to say the Nuliarima case is one of the most heartbreaking cases I've ever read in my whole legal career. The full court of the Federal Court in Australia examined Australia's history involving Aboriginal people in light of the international crime of genocide. And each of the judges acknowledged that genocide had the status of customary international law and also the status of jus cogens, which means that no derogation is permitted from the norm. But they ruled that genocide was not a crime under Australian law in the absence of domestic legislation declaring genocide a crime. So there was a whole discussion in the case about whether customary international law could be incorporated by judges as part of the common law, as happens in the United Kingdom. And the court held in this case that it couldn't, because on the one hand, there's no crime of genocide in Australian domestic law. There's a principle that you shouldn't be charged with a crime that's not on the statute books. So for many reasons, this was not a case in which the judges could say it was part of the common law. But after this case, Parliament introduced legislation which then criminalised genocide under Australian domestic law. So with regard to genocide, there was no uncertainty about whether it was a norm of customary international law. But with customary international law, one of the problems can be its uncertainty. So it can be difficult for domestic courts to identify exactly what a rule is and whether it has the status of customary international law. And in these circumstances, courts will look at state practice, what states do and say, and whether there's any evidence to show that they've acted in that way owing to a legal obligation. So this brings me to say a few words about the case that I was recently involved in. If we can go to the next slide. So the case that I was involved with involved the Bangala people, who are Aboriginal people in South Australia, whose traditional lands covered much of the Eyre Peninsula. And they're considered to be the traditional owners of that land. And you can see there's a map, and there's a place there called Kimba on the Eyre Peninsula. So the case was brought by the Bangala people against the Commonwealth of Australia in relation to a decision by the Commonwealth to put a nuclear waste dump at a place called Napandi, which is fairly close to Kimba. And we can go to the next slide. This is a group of the Bangala people who were protesting about this decision of the Commonwealth Government outside the federal court in March this year. And they were opposed to having a nuclear waste dump on this land, as the land was considered important to their culture. It's a site of an Aboriginal dreaming story about 7 sisters, and they fear that if they put a nuclear waste dump on this site, it would break the song lines about this story and would harm their culture irreversibly, and also their relationship with the land, which they refer to as country. I won't go into detail about the case, but by way of background, it involved a constitutional law challenge to national legislation under which the land at Napandi had been selected to be a site for the nuclear waste dump. And the Bangala argued that this law was ultra vires, as it wasn't a proper exercise of the external affairs power of the Constitution. The National Act under which the Minister had selected the site had been adopted so as to implement an international treaty to which Australia is a party. It's called the Convention on the Safety of Spent Fuel Management and on the Safety of Radioactive Waste Management. And it was argued that this treaty had to be interpreted in light of relevant rules of customary international law. And it was argued that there were certain norms in the UN Declaration on the Rights of Indigenous People, that Indigenous people have the right to cultural heritage and identity and to their traditional lands, and that these norms have the status of customary international law. So this is just one aspect of the case, but it led to some very interesting evidence and submissions. And the Bangala people obtained expert evidence from a high-profile barrister in London called Timothy Ottey, KC, and he gave an expert report setting out state practice to prove that these norms have the status of customary international law. And then the Commonwealth, they got their own expert, Professor Akande, from Oxford University, and who's also a member of the UN International Law Commission, and he set up a comprehensive report showing evidence to the contrary, that states didn't consider themselves binding in relation to these norms. So at this stage we're waiting for judgment, and it'll be interesting to see how the federal court approaches the matter. So the court has in effect been asked to determine whether these norms concerning Indigenous people have the status of international customary law. Now, I imagine this is not going to be an insignificant task, and it's also one that they won't take lightly. People in Australia and around the world will take notice of what the court says on this issue, and the court probably wishes it hasn't been put in this position by the applicants in this matter. So I'm now going to come to the final part of my presentation this morning. And I'm going to talk about, so I've given you all the background in terms of how it works in Australian law, but what are the opportunities for practitioners in Australia in terms of using international law? So there are 3 ways in which international law can be useful in domestic courts. It can be used in interpreting legislation, where the legislation is ambiguous or uncertain. It can also be used in judicial review applications. where it can be argued that provisions in treaties which Australia has ratified can give rise to a legitimate expectation that the executive will act in a way that's in accordance with obligations under the treaty. And it can also set standards. It can also assist in the development of the common law, where international law can be used in terms of filling gaps in the common law. In respect of international law, in Australia generally, the courts are fairly conservative and they take a strictly dualist approach. And I believe that this is due to the constitutional framework and legal traditions in Australia. Even though Australia is a common law country with English common law traditions, just like India, the UK itself is a party to a regional human rights treaty, so the courts in the United Kingdom take a less conservative approach than Australia does, and I think that that's probably in part due to the fact that they are part of this European Convention on Human Rights. And I know that India has a Bill of Rights in its constitution, and I wonder whether this aspect of Indian constitutional law would make it more likely that the Supreme Court of India would adopt an approach which is more like the UK or more monist in some aspects, particularly in the area of human rights. So I'd be interested to hear the position on that. I should note that in terms of using international law as an interpretive aid where there's ambiguity, that principle has quite a lot of support from the Bangalore principles. And I don't know if you're aware of the Bangalore principles, but back in 1988, a former Chief Justice of India, P.N. Bhagwati, convened a judicial colloquium in Bangalore on the domestic application of international human rights norms. And this was attended by high-profile judges from all around the world, and they included Ruth Bader Ginsburg from the Supreme Court of the US, and there was also Justice Kirby from Australia, the High Court of Australia. And it adopted a number of principles on the role of the judiciary, including in terms of promoting human rights by reference to international human rights norms. We can go to the next slide. So in the Bangalore principles, these judges declared that it was within the proper nature of the judicial process and well-established judicial functions for national courts to have regard to international obligations, whether or not they've been incorporated in the domestic law, for the purpose of removing ambiguity or uncertainty in constitution, legislation, or the common law. They also adopted this principle that judges should keep themselves informed about relevant developments of international law, including international conventions and other instruments establishing human rights norms. So I think that's quite significant, and I know that these principles have now been adopted by the Economic and Social Council of the United Nations as being, in terms of standard setting for the judiciary. I mentioned earlier Tio's case about the Malaysian man who was to be deported from Australia, and he argued that the minister had erred because hadn't taken into account the best interests of the child. So if we go to the next slide, in that case, the court actually held that he did have a legitimate expectation that the minister would take into account the effect on his children. And this has now given rise to a body of law whereby you can challenge administrative decisions in judicial review proceedings where the decision maker hasn't acted in accordance with Australia's international obligations. In that case, the High Court held that he'd had a legitimate expectation as to the process that the minister would take, and that hadn't happened here. It's quite interesting because after that case, there were, I think, about 3 attempts by federal parliament to adopt laws to say that it doesn't create a legitimate expectation, but these have all failed. If we can just go to the next slide. Apparently there is a law in South Australia which says that it doesn't give rise to a legitimate expectation, but that is not the case federally. The final use is filling a gap in the common law. And we have a very famous case in Australia called the Mabo case, which concerned the rights of Aboriginal people to their traditional lands, and which is very significant because it overturned the doctrine of terra nullius in Australia. And in that case, Justice Brennan of the High Court noted that an expanded doctrine of terra nullius in international law, which didn't recognise land as being occupied if it had been occupied by Indigenous peoples, no longer applied in international law. And Justice Brennan noted that and modified the common law in Australia accordingly, because he said that there was no basis for it and the common law had followed international law. So to conclude, I'd like to raise some questions for the discussion, which I believe apply to both India and Australia as having dualist systems of law. So these are, what are the benefits of maintaining a strictly dualist approach, as is the case in Australia? Does this ensure that our laws will be more democratic because they're enacted by Parliament, rather than international laws ratified by the executive and then being incorporated by judges? And what are the downsides to this approach? Does international law provide a contemporary source of law that could be used to fill gaps, rather than raking over the coals of ancient English common law? Thank you.
Does anyone have any questions for Katarina?
I now request a second speaker for today to take over the this. Thank you.
Good afternoon, everyone. So my name is Rajendra. I have been a practicing litigator for about 25 years now, and I should say that I've done a lot less work when it comes to very, very interesting subjects that we heard Katrina speak about. So I hope I pronounced that right. So public international law. Let me start by saying this, that I think the process that is adopted by India and Australia is kind of similar. So we heard that it's not the approach that you would typically see, for example, Netherlands take, and we would still, in a sense, largely lean on our municipal law. So it's more or less the same. What I'm going to briefly speak about is what is the impact of international law when it comes to domestic courts. Now, some very basic principles when it comes to international law. We know there is public international law and there's private international law. Private international law really is not the subject for the day. When it comes to public international law, it's the legal responsibility that a state has when it comes to its conduct with each other and the treatment of individuals within the state boundaries. So, what are some of the issues that public international law would deal with? It's global concerns such as general human rights, disarmament, migration, nationality issues, treatment of prisoners, but then things which are more closer to our heart, things which affect our day-to-day life, which is stuff like environmental preservation, international waters, outer space, world trade. So yes, it's correct. We have adopted a dualist approach, which means that simple ratification of a treaty or convention by India does not suffice for enforcement. There has to be express translation into municipal law for it to be applicable in the domestic legal system. Now, what really is the principle? The principle comes from the fact that we go on the basis that international law has a different character as compared to domestic or municipal law, and therefore we need the two to align. We expect the two to be such that there should be no conflict. Having said that, and as I would address you further, there are on principles of public international law, but when it comes to possible conflicts, Indian courts have recognized that they cannot legislate. They are there simply to implement. And therefore, as implementers, they are bound by the municipal law. And therefore, they have said that even if we want to, we can't really go beyond what our legislation tells us. Now, the fact that we have an approach which is the dualist approach has also been recognized by our constitution. Our Article 253 of our constitution empowers the parliament to make any law for implementing a treaty, agreement or convention with any other country, or to implement a decision which is made at an international conference, association or other such body. Effectively, therefore, the expectation is that international law has to be transformed into domestic legal system before it can be enforced against individuals or juristic persons. Interestingly, we also have an Article 51C of our Indian Constitution, which says we should foster respect for international law and treaty in dealings of organized peoples with one another. However, as all of us know, Article 51 is a part of the directive principles of state policy, and therefore it's not really enforceable by a domestic court. Now, so therefore, just a few takeaways, and there's an interesting takeaway that we heard by my co-panelist when she was talking about the Bangalore principle. And as all of us know, Justice Bhagwati is the judge of the Supreme Court who empowered this whole concept of what we call public interest litigation. Now, what has public interest litigation contributed to the Indian society is just huge. And very clearly, it is a lot of that public interest litigation and the judicial precedents that came out of public interest litigation that we've seen vital principles of international law being drawn into. For example, when it comes to a lot of MC Mehta judgments, and I'm sure all of us are alive, what he has unknowingly contributed is some leaps when it comes to stuff like the absolute liability when it comes to environmental law, or when it comes to the polluter pays principle. I've always, I've been a law student of the Bombay University. I've done my law from Government Law College, and I know we had a professor who always used to say that lawyers are trained to look at the way things are and not as how they should be. But it really is what we've seen from some of these judicial precedents, where judges have taken a step beyond and have really decided to do what a typical lawyer would not do, which is not just look at the way things are and try to see how things should be. So Justice Bhagwati was an excellent mention, and therefore to that extent, that's one important factor that we've seen. That's one important, you might want to put this off. I was talking about pollution and I could hear water. So it's like, now, has India contributed significantly? There are global writers who recognize that while we've taken a dualist approach, we've still contributed significantly in drawing from international principles. be it human rights law, and we heard Justice Jadhav speak about Kasab. And I remember having a very interesting discussion with my son, who was in his teens and who strongly believed that if you caught him on a camera spraying bullets on human beings, what then is rule of law? Why do you need rule of law? Of course, there are some very interesting debates which come up when you see instances like what we saw in Uttar Pradesh last 3 days on how does that tie in with rule of law. I think those are controversial subjects which I would simply mention and not give a view on. I mentioned environmental law. We have empowered ourselves tremendously from global treaties and from what I would call public international law when it comes to environmental law. On arbitration, which really is the primary area that I practice in, and I can possibly take the whole day to speak about how we have learned from sound, well-defined international principles, not only on law, but how to conduct an arbitration. But that is a smaller example. India saw a BIT against India in a case called White Industries. And I don't know if all of you are familiar with the facts of that case, but White Industries was enforcing an arbitral award in the High Court of Calcutta. The matter did not come up for hearing for about 12-13 years. And therefore, White Industries decided to go under the bilateral investment treaty and sued the country. And that resulted in an amendment to our Arbitration Act in 2015, where an Arbitration Act was made much more stronger after that. We've seen instances of Indian courts relying on international treaties when it comes to trade law, of course when it comes to international waters. But having said that, there is reluctance when the sovereignty of the country is concerned. And that goes back to the principle that India and Australia follow when it comes to international treaties. So, I've come across several judicial precedents where the Supreme Court has held, and I'm going to give you some names as we go on, that municipal law needs to change to accommodate the treaty. The perfect example, which I again see in my operations on a regular basis, is the Hague Convention on Service. The mere ratification does not mean that it's enforceable. And so therefore, if there is service of documents which one has to give effect to, there is often a debate about how would you do it. More so in circumstances like COVID, where Indian courts had started recognizing even service by WhatsApp as valid service, which is quite in the teeth of Hague Convention. The Supreme Court has also clearly said that treaty entered into cannot become law of land unless the Parliament passes a law. It goes back to the same principle that we spoke about, Article 253. In the beginning, in the opening session, we heard about the obligation under Article 27 of the Vienna Convention that a state should honor international obligations and change its domestic law. But quite obviously, there will have to be a lot that one will have to deal with when you are dealing with your own domestic problems. Again, I don't intend to speak about it in detail, but when I have spoken with a lot of friends abroad, or when I've spoken at international platforms in the recent past, Ukraine, Russia, and India's stand has often been issues that have come up. Now, this obviously is the perfect example of how India will have to deal with its own domestic problems, will have to deal with its own domestic realities. And so therefore, to that extent, while we've seen the Indian courts draw on international treaties, the sovereignty obviously has been given a priority. So, what has been the approach of Indian courts? The transformative approach that was taken by the Indian courts was reiterated by an earlier judgment of the Supreme Court in Maganbhai Ishwarbai Patel versus Union of India It's a AIR 1969 Supreme Court judgment where the case dealt with an adjustment of a boundary with another country. The Supreme Court stated that while a treaty or an agreement executed between two states would be binding on the states, the obligations which arise out of such treaty would not by their own force bind Indian nationals or residents. It is necessary for the Parliament to make law which adopts the treaty or the agreement, especially when the same restricts the rights of the citizens. Sometime during the 1980s, there was a shift in the Indian jurisprudence from the strict dualist to transformative approach. At this time, the court started incorporating international law into municipal law without any need of adopting it into legislation. We saw Gramophone Company of India versus Virendra Pandey, which is 1984 Supreme Court 667, where the Supreme Court stated that national courts would endorse international law, but only if it does not conflict with domestic law. Therefore, while the incorporation doctrine was adopted, it was subject, of course, to the municipal law in force in India. Interestingly, during this time, while our Indian Supreme Court, and I've only taken Supreme Court judicial precedents, although I've come across a few which are Calcutta High Court, etc. But I thought Supreme Court really being, our Article 141 court. So Supreme Court was hesitant to expressly subsume international law and covenants in the domestic legal system. It was dealing with a case in Jolly George Verghese versus Bank of Kochi, where a debtor who was unable to pay amounts due was slapped with imprisonment under Section 51 of the CPC. And Justice Krishna Iyer, there was the argument made before him that the detention of the debtor in prison in execution of the decree would be contrary to Article 11 of the International Covenant on Civil and Political Rights. The Supreme Court admitted that until municipal law is changed to accommodate ICCPR, the provisions of CPC would bind the court. However, it also, in a sense, brought Section 51 of the CPC in line with Article 21 of the Constitution and made it ultimately consistent with the principles of Article 11 of ICCPR. However, as all of us saw, the incorporation approach, if I may call it, was constantly used in Indian courts, and the most ideal example was Vishakha versus State of Rajasthan. Now, Vishakha versus State of Rajasthan is where the concept of sexual harassment at workplace was introduced absent any judicial basis. Absent any legislative basis. And the Supreme Court held that in the absence of any law in India governing sexual harassment in workplaces, international covenants can be referred to if they are not inconsistent with fundamental rights and if they promote the objects of the constitutional guarantees. It was only after almost 20 years that we saw a statutory basis for investigation needed in the complaint of a sexual harassment. The trend continued, and when it came to Vellore Citizens Welfare Forum and the concept of sustainable development, which is in 1996, 5 SCC, page 647, where sustainable development as customary international law was held to be a part of domestic law, and subsequently the international norm of polluter pays principle was introduced in NC Mehta versus Kamal Nath in 1997, 1 SCC, page 388. Now, despite all these excellent developments, I think the underlying principle remains constant, that international law can be transposed or can be relied upon and enforced by domestic courts if it does not contravene municipal law. But where it contravenes municipal law, courts have recognized that absent amendments, they cannot rely on it. We've also seen principles of international law have its effect upon commercial laws, in commercial proceedings. So in Entertainment Network India Limited versus Super Cassette Industries, which is where the issue before the court was in relation to India's obligations under various copyright-related international conventions, the Supreme Court observed that interpretation of domestic statutes cannot remain static. It also outlined the role of international law and domestic legal systems as a tool of interpretation to fill gaps in law, to fulfill the spirit of India's international obligations, and to provide relief given in international covenants but not in national law. Similarly, the Supreme Court reiterated the incorporation principle by stating that international law norms would be applicable in India as long as they do not conflict with Indian laws. In Aban Lloyd versus Union of India, which is 2008-11 SCC 439, where it was held that the Maritime Zones Act 1976 was not in conflict with the United Nations Convention on the Laws of the Sea 1982. So, briefly now in conclusion, I think it would be fair to say that absent a specific provision in our municipal law, international law will not have teeth in India. It's an interpretative tool, or it's used to fill gaps in legislations or enunciate general principles of law. However, more often than not, international covenants, although ratified by India, are not transformed into municipal system through executive action. There may be merit, therefore, in reinforcing the aspect of legitimate expectation under administrative law and international law. The legitimate expectation of citizens that the state would adhere to international principles that it is ratified was recognized by the Supreme Court in Visakha. And interestingly, it relied on the Australian case of Minister of State for Immigration versus Teo. However, in the case of People's Union for Civil Liberties versus Union of India, which is a judgment in 1997-3 SCC 433, the Supreme Court was reluctant to rely on Teo by stating that the concept of legitimate expectation vis-a-vis ratification of treaties by the state would require deeper scrutiny. This was because, as per the court, it's only the parliament which can legislate, and mere ratification of a treaty will not give it the sanctity of law. So, I think to sum up, let me just see. To sum up, as we've heard Khalid say, हजारों ख्वाहिश है ऐसी कि हर ख्वाहिश पे दम निकले, बहुत निकले मेरे अरमान लेकिन फिर भी कम निकले. So I think while we see leaps that are courts are taken, and that has resulted in tremendous impact on day-to-day life, there is still a lot desirable when it, for example, comes to human liberty, for example, when it comes to environment, for example, when it comes to trade laws. But I'm sure that we are conscious that we are balancing multiple balls that we're dealing with. And so therefore we know which are the ones that we need to be careful about. And at an appropriate time, we would expand our horizons sufficiently. Thank you very much.
Thank you very much. Does anyone have any questions for the speaker? Don't be shy.
From the talks, the beautiful talks that we have heard from you speakers, there is this assessment perhaps that can grow that as time has passed, the extent to which we are accepting international law into our domestic legal system, that trend has been increasing. It has been something that has been happening more and more often as time has passed in different fields. Can we say that as India has grown in prominence from the time when we became independent to the time today when we have grown bigger as a nation, we have a greater international stage, we see ourselves now as more of a participant in the framing of international law, and that is why we have learned to accept it more. Whereas in earlier times, perhaps we tried to assert our sovereignty because we did not see ourselves as contributors to the framing of international law. Can we say that?
Can I take that? But you go first. I'll take it.
It's kind of like, I don't know if this is working, but I'm always intrigued when people raise the issue of sovereignty when it comes to issues to do with international law and international organisations. Because it is an act of sovereignty to ratify a treaty. That is an act of sovereignty. I just wonder whether it's a democratic issue that you have the executive ratifying treaties without consultation of the population. There isn't a democratic lawmaking process for ratification. So I wonder whether it's more about democracy, sovereignty. But I know that when the UK left the EU, everyone was talking about, oh, we're getting our sovereignty back. But joining the EU was an act of sovereignty. It was the United Kingdom saying, we want to be part of the part of the European Union. So I don't understand that argument.
So Sheetal, I think I would again go back to very basics. So when I come from a time, I've always been a Bombay boy, and having a telephone line in your house used to be a luxury. Making an STD call was a huge leap. I mean, I remember, and I don't see many faces here who would relate to the concept of booking a trunk call. But you have to book a trunk call, and how things evolve. The point I'm trying to make is how things evolve. So there used to be tobacco traders in district Khera in Gujarat, and when you used to book a trunk call, you could do what was called a PP, which was a particular person. So if I wanted to book a call, then I would say I want to speak on this number, and it would be particular person Sheetal. So the operator would call up and say, there is a call from Bombay for you, and is Sheetal there? And Sheetal would say, no, Sheetal is not there, but Rajendra is there, which was an implied signal to me to tell me that the markets today are not bullish, they're bearish. And I would say, no, forget it, I don't want to speak, and it used to be a free call, very akin to the missed calls that we saw before telecommunication became practically so cheap that nobody gives missed calls these days. So the concept I was trying to tell you was, and you were saying India and India's contribution. I strongly believe that the strength of India comes from the fact that we are have-nots. When I speak to my friends, I tell them that you speak to a taxi driver in India. His aspiration would be very different because he's a have-not. And when we are today the largest country in the world, Mr. Ambani said this, that from a 1.4 billion people of problems, we have 1.6 billion people of opportunities today. So yes, we are playing a role in, and whether we like it or we don't like it, in shaping, I wouldn't say the global politics, but certainly the politics in the area. And to that extent, even if we want to, I don't think we can quarantine ourselves or stay immune to what the global trends are. Most of those global trends are captured in terms of a convention or a treaty. And so therefore, I think whether we like it or we not, we will have to keep adapting and therefore in turn contributing. That's the way I look at it.
Hello, this is Preeti Brahmanya. Mr. Barod, I got a question for you. You mentioned that the topic for today is public international law. But we see that even if it is a private international law or public international law, somewhere it goes down to having linkage with the public international law. Because even if you are a private individual into some kind of trading or something, somewhere your government also gets involved. And also there was a example which was given by Justice Sadhna Jadhav, which was regarding the case where there was an hostile couple and there was a matrimonial dispute. So we see there are these things like lex quori, lex causi, lex loci. And it's more like how complicated it's been, to decide as to where and what. So always we feel it is the law of the land, or it could be the law of the nationality of the person from where he belongs. So somewhere we see, and though it is called as private international law, we generally use the term conflict of law because it is more related to the conflicts which are there between the nations. So do we foresee something where we zero it down to international law, where we have both the things coming on the same platform, and it's more of the nations with the World Trade Organization, with WHO being in place? There are a lot of things which we see internationally where we face problems. So instead of having that conflict and resolve it, and how do we foresee that? Because we've seen the Vodafone case as to how complex it was. We have seen in terms of international regime of insolvency, we've seen the Jet Airways. So where do we foresee the things in future?
No, thanks, Mary. So I think three answers. The first answer is you can't really put the two streams of law into two separate buckets. I think there's bound to be contamination because and so therefore, in a sense, for example, I'm arguing right now in the High Court in relation to an NT arbitration stay, and I'm trying to enforce an order which has come from a court in Singapore. And what is being cited against me is an order that was passed by the Delhi High Court in relation to a case filed in China. Now, all of us are seeing a fair bit of action when it comes to, say, for example, proceedings being filed in Russia or in China. And when those are cited as judicial precedents, the dividing line is very thin. Are you dealing with commercial contracts or are you dealing with issues of public international law? So I think there is no simple answer. The second thing is, as I told you, that as a lawyer, your first training, well, at least my first training, is to look at the way things are and not as how they should be. And I think that is where necessarily the amoeba of interpretation keeps changing its shape. So what is relevant 5 years back is not relevant today. And I don't think it's going to be relevant 5 years hence. And the third thing is, certainly we are seeing boundaries shift when it comes to India. To give you a simple example, and I've also been a transactional lawyer for about 10 years. And in the early 2000s, when we used to deal with, and we were a very small boutique law firm of about 10 lawyers. And 100% of our clients used to be foreign clients. For example, we've done a lot of work for Telstra. The typical arbitration clause, it was a no-brainer that the arbitration clause used to have seat outside India. It was a no-brainer that the argument always was whether it will be the English law that will apply or whether it will be the Singapore law, but it will be some other common law jurisdiction law. From where times have shifted today to where the negotiation now is, it stops at saying Indian substantive law shall apply. And there's hardly any debate on that. And there is a strong debate on whether the seat should be in India or it should be outside India. So in a sense, there is a certain shift. And the shift is what is going to define what's going to be the platform ultimately. Where are you going to land when it comes to having a common principle of whether you call it impact of international law, more generic, rather than getting into public and private. I don't know if that answered your question.
Please. Glad you took that one.
We've got someone there who wants to ask a question, yeah?
A very good afternoon to the panel. It was very insightful hearing you guys. I had a question for both the speakers, starting with ma'am. As a member who's worked with the UN, how do you think UN conventions or treaties can be applied more to the dualist countries, especially Australia and India, since both of our countries have the dualist approach?
Well, I think that's a very good question. I think that it would really take some really significant decision by the High Court of Australia, which is our highest court, to find an appropriate situation in which to import a provision of a treaty as part of the common law. And I think that in the Mabo case, Justice Brennan started to pave the way for something like that to happen. I think, I don't see anything happening in the very near future, but maybe in 10 years' time or something, there might be the right kind of case. One thing I reflected on whilst I was preparing my presentation for today is that a lot of the cases in Australia that involve public international law actually involve issues to do with Aboriginal people, and it's really, it's their situation where the laws, the current or the previous laws in Australia didn't address their needs. They were looking outside to international norms, trying to find support. And I imagine that, there could be similar parallels with situations involving environmental protection where domestic laws haven't caught up with changing circumstances.
Thank you, ma'am. My next question was, what is your opinion? Should the international laws run parallel to the domestic laws, or should they intersect and work together?
Well, I think for now, and I partly addressed that when I spoke, the dualist approach, in a sense, has the answer very clearly laid down. So if there is conflict, the municipal law prevails. And when there is no conflict, and which in a sense also answers your first question, that the Indian Supreme Court in Vishakha, for example, or in MC Mehta, has dealt with instances where there was no conflict, and they've drawn from international principles.
Thank you, sir. Thank you, ma'am.
So can I ask you a question? So this is regarding international arbitration. I was drafting an MOU a few days back, and the arbitration clause said that one of the companies is from India, another company is from United States, but they together decided mutually that the seat of arbitration should be in London. So my doubt is that a country which, either of the countries' domestic laws will not be applied. And the domestic, and there's an international judgment which also says that the seat of, wherever is the seat of the arbitration, the law of the land of the same country apply. So would this not actually be very chaotic if such a trend keeps, happening on daily basis, that there are two different countries, two different laws, and the seat stands in some another country?
Well, so Vidhi, I think the first question is what's going to be the substantive law of the contract, which is what the two parties should ideally make it very clear. The second question would be the municipal law, which is going to be the law of the seat. And the third question is what's the applicable law when it comes to the arbitration act, the arbitration agreement. And if you see, there is a recent Singapore High Court decision in Westbridge, which deals with that question extensively, where they say that the first answer always is the substantive law of the contract. However, if you look at the question involved, and in the case of Westbridge versus Anupam Mittal, the Singapore court has laid down that given the facts of the case, it has to be the law of the seat that applies to the arbitration agreement. So I think to answer your question, courts recognize that sophisticated corporates want corporate democracy. So if they consciously want a certain law to apply to their commercial relationship, they should be free to do it. If they want an arbitration clause, an arbitration which is basically a court which is creation of a contract, they are allowed to do it. And if they therefore by their contract choose that the law that will govern their own creation, which is the arbitration tribunal, is going to be X or Y, it should work. The simple advice to you is, if your arbitration clause is simple and clear, not very complicated, a lot of these questions resolve themselves.
Thank you, sir. Are we expecting any more questions?
Sir, pertaining to that, I'm having one question. Are we promoting as an Indian government, are we promoting seat of arbitrations in India? Like if you compare with the Dubai, it's a fairly new player in the market. They are promoting the seat of arbitration. So in India, as an Indian government, are we promoting the seat of arbitrations in India?
Again, I think three answers. The first answer is, and so I often have these questions asked to me when they say, is Singapore, for example, do you know that SIAC, more than 60% of SIAC's business comes from India. Now, why is that? So you need to understand that and Singapore government is doing an excellent job. I'm not trying to belittle what they're doing, but it's Singapore, right? It's a point. You're talking about the elephant called India. So the elephant right now is trying to walk, it can't dance. Therefore, it's very difficult for India to establish itself as an arbitration hub. That's the first thing. The second thing is, if I ask, and I can see a lot of students here who still haven't really shaped their careers. How many of you all see yourself becoming Harish Salve? I mean, if you were to dream. And Harish Salve is a famous KC who is known to be very, very busy. And I'm just taking that name as an example. So how many of you want to become Harish Salve? Can I have the hands up? And how many of you all want to become Justice Chandrachud? Okay. But so I can tell you that I have seen that nobody wants to become a judge. That's one more reason why delay in Indian courts is a huge problem. And I think the third and the most important aspect is Indian courts are struggling right now with what they've already bitten. So, as they say कि घर सजाने का तस्वुर तो बहुत बात का है, पहले ये तय हो कि इस घर को बचाएं कैसे. So I think if we can take care of what we've bitten, that will be good enough. So these are the challenges that I clearly see in India becoming an arbitration hub.
Yeah. And my second question will be for Katrina. You work very closely with UN. As they say, data is the new oil and data is the new gold. How Australian government or Australian judiciary system sees the data transfer in perspective of PI data, the personal data of Australian citizen is coming to India for the processing. So the new Australian laws are coming, the new Australian data privacy laws. So does Australian government have any view on that?
So sorry, but I really don't know.
But if I can tell you the Indian part of the story, quite obviously all of us know how often your data is being abused, misused, whichever way you want to put it. I mean, how often do we get those crank calls and you wonder where they're coming from? There's a lot to desire. The problem again when it comes to India, it lies in enforcement. Say for instance, and I'm sorry, I just keep jumping back to examples, but how many of y'all have heard here of TN Session? So we had an election commissioner called TN Session, and prior to him coming in power, elections used to be a noisy affair. There used to be posters all over. There were no rules that were followed, and he came in, and he was executive. He was not legislation, so he had no power to legislate. All he did was he just simply put what was there into action, and that resulted in the whole concept of election changing completely. So when it comes to, for example, data, if the existing laws are enforced, there are enough and more laws to deal with it. But unfortunately, all of us know the struggles. All of us get these calls where say your electricity meter is going to be disconnected today unless you deposit 3,000 rupees.
Yeah.
So that just is the way it is.
With this, we now come to the end of the technical session 1. I would like to thank all the panel members for their time and words of wisdom. We would now break for lunch, post which we'll proceed to technical session 2. Thank you, everybody.
What time they should join?
Just to mention, we'll start the technical session 2 at 2 p.m. sharp. So everybody is requested to come back to the hall around 1:50, 1:55.
कसं सॉरी